Our immigration court in Michigan also is responsible for the immigration practices in Ohio. So our 5 immigration judges in Michigan also cover immigration for Ohio. Each of our 5 immigration judges has a caseload of 42,000 cases. 42,000 cases. So our immigration judges, as you probably can imagine, are quite busy. So the 5 agencies are, again, U.S. Immigration, we call it USCIS, U.S. State Department, or the National Visa Center, U.S. Customs, U.S. Immigration and Customs Enforcement. And as you probably all have heard in the last few days, we refer to that as ICE. U.S. Customs and Border Patrol. Those are the people that you see when you come back into the United States at the airport. We call them CBP. Now, there's also another agency that has a minor role in general immigration processing and adjudication, and that's the U.S. Labor Department. 5 distinct agencies all have some function and power and enforcement ability in U.S. immigration. Of course, ICE, Immigration Customs Enforcement, and U.S. Customs and Border Protection, the officers you see when you're coming back into the United States at the airport, they are the law enforcement arm of U.S. immigration. They are the ones who arrest people. They are the ones who detain people. They are the ones, ICE and CBP, they are the ones who place people in deportation and removal proceedings in U.S. Immigration Court. So ICE and CBP are the enforcement arms. U.S. Immigration Court is the adjudicating arm, as well as U.S. Immigration, USCIS. USCIS and U.S. Immigration Court are the adjudicators of petitions and applications that are filed. CBP and ICE are the law enforcement arm. They are the ones who arrest and detain people. And just to give you a bigger perspective about U.S. immigration in the United States, immigration is divided into 2 large segments. There are non-immigrants and there are immigrants. Non-immigrants are those whose entry and visa indicate that they're coming into the United States for a short-term duration. That's usually 3 to 6 years. And when we talk about non-immigrants, we're talking about people who don't come, whose visa and admission does not indicate that they're coming into the United States to permanently live and work. So we're talking about B1, B2 visitors visas. We're talking about F1 visas for students. We're talking about J exchange student visas and all your temporary work visas, the H's and the M's. All of those are non-immigrant statuses. So they are persons who are coming into the United States with the intent to work, to stay in the United States for just a short duration. Usually those visas, except for the visitors visas, your B1s and your B2s, are generally given for a duration of 180 days. The other visas, your student visas, your J1s, all your H's, generally have a durational status of 3 to 6 years. They're all non-immigrant visas. And the larger portion are immigrant visas. So these are persons who are coming into the United States to live, reside, and work permanently. So if you are a U.S. citizen and you're filing a petition for your spouse, your parent, or your children, those are considered immigrant visas. and immigrant statuses, because the person's intent is to come, live, reside, work in the United States permanently. So those are the two big divisions that U.S. immigration deals with on a day-by-day basis. Now let me just give you a little bit more perspective about immigration today. Currently, U.S. immigration has a case backlog of 4,639,000 cases. We've never seen this in our history. This is the first time in the history of the United States that we have seen a backlog like this. 70% of that 4,679,000 cases are persons, foreign nationals, coming in from Venezuela, from Argentina, from Nigeria, from Czechoslovakia, from Albania, from Romania, from Mexico, from most of your European countries. So a lot of the backlog that we're seeing are people coming into the United States either without a visa and without lawful immigration status, and they're coming to a port of entry. And they're saying, I'm afraid if I go back to my home country, I will be persecuted by my government because of my race, my religion, or my political activities. That application at our U.S. Customs and Border Station is called political asylum. So I mentioned to you that there were non-immigrants and immigrants. So now you know there's also a third segment of U.S. immigration that deals with political asylum. Political asylum is an international law. All the countries that are part of the United Nations must enact laws and statutes that deal with international law. Political asylum is an international law. The United States is a treaty to that United Nations Convention on Asylum. So whenever you hear a lot of times on the news, ICE and U.S. Customs and Border Protection talking about all the illegal people who are coming into the United States, well, that's not true. It's actually a misrepresentation. Our international treaty with the United Nations and our domestic statutory law in the United States confirms that anybody who comes to a port of entry who says, I will be persecuted if you send me back to my home country, I will be persecuted by the government because of my race, my religion, or my political activity, international law says you have to let them in to make their case. And that's not an illegal entry. That's a lawful entry so that they can file a political asylum claim. So when you hear all these rumblings on the news all day long from ICE and from CBP and from, unfortunately, our president, who talks about all the illegal people coming into the United States, 70% of those people are coming in legally under international law. They're not illegal. They're people coming into the United States to seek political asylum because they believe they have a legitimate fear. If they return to their home country, they will be persecuted by their government because of their race, their religion, or their political activity. So, we have non-immigrants, we have immigrants, we have asylum seekers who are seeking admission into the United States based on their rights under international law, political asylum, and there's one other section that immigration deals with, and these are people who are coming into the United States claiming that they were persecuted. Again, harmed by your government because of race, religion, or political association is political asylum. tortured by your government because of your race, your religion, or your political association falls under the United Nations Convention Against Torture. Again, the United States, as well as all countries that are members of the United Nations, have to have a domestic treaty that covers persons coming into the United States who are complaining against torture by their government because of race, religion, political activity. So these are the quadrants that U.S. immigration deals with. Non-immigrants, immigrants, people seeking political asylum, people coming into the United States seeking protection under the United Nations Convention Against Torture. All right, now let's do, any questions so far before I do a deeper dive into what's going on in the United States today relative to immigration? Okay. Again, remember, we have a current backlog of 4,659,000 cases. We have 5 U.S. immigration judges in Michigan. They are responsible for determining who stays in the United States, who gets removed. Each of those judges have a caseload of 42,000 cases. And they are also responsible for the immigration activity in the state of Ohio. So our judges are busy. Now let's talk about your rights and what's going on in the United States. As you probably know, our federal executive branch has instituted about 130 executive orders since President Trump took office. 85% of those executive orders target immigration. Immigration, as I told you, is controlled, delegated by 5 agencies of the federal government. So the executive branch has a huge part to play in immigration. They can proffer federal regulations that stipulate how our various agencies can perform their functions to administer or enforce or process immigration petitions and applications. But the laws for immigration, the statutes, of course, are enacted by Congress. Congress is the body that makes immigration law. It's not the President of the United States. Congress is the body that determines whether or not certain agencies get federal funding. It's not the President of the United States. Congress is the one who determines whether or not the Aliens Enemy Registration Act is lawful. Well, I strike that. Congress is the one who enacts the Alien Enemies Registration Act, but it's the courts who determine whether or not any activity pursuant to the Alien Enemies Registration Act is lawful or constitutional. It's not the President who determines that. So, what's going on today? We know people are being arrested and detained by Immigration and Customs Enforcement as they walk out their door. We know people are being arrested and detained by Immigration and Customs Enforcement as they drive their car on our streets and highways. We know that people are being arrested and detained by ICE as they enter their door to their work of employment. Can they do this? Does ICE, does CBP, U.S. Customs and Border Protection, have the legal power and authority to do this? They probably do. Because as I told you when we started this, the enforcement arm of U.S. immigration is ICE, Immigration and Customs Enforcement, and U.S. Customs and Border Protection. They are the ones who are charged by our laws and by Congress to enforce. They are the law enforcement officers for immigration. So yes, they can probably come to your home, knock on your door, but only with a judicial warrant that's signed by a judge, not with an administrative warrant that's signed by Homeland Security. They have to have a judicial warrant that's signed by a judge that gives them the authority to search your home or to search you and arrest you. If they come to your home without that judicial warrant signed by a judge, you, as well as anybody else who is physically present on U.S. soil, and this is important, you have to know what our Constitution says. Our Constitution guarantees rights to persons. It doesn't guarantee rights to citizens. It talks about persons. Persons who are physically present in the United States have constitutionally due process rights. Persons, not citizens. Now, citizens, of course, we don't have rights too, but I'm trying to distinguish between what the Constitution says and what the federal government says who has rights. Anybody who lands on U.S. soil, the Constitution wraps around them and provides a suit of due process rights. One of those rights, of course, is the Fifth Amendment right, the right to remain silent. So if ICE comes to your house, they want to talk to you, they don't have a judicial warrant signed by a judge, you have the right to invoke your Fifth Amendment right. I choose to remain silent. I will not answer your questions. You do not have to open the door for ICE if they come with a warrant that's not a judicial search warrant. You can speak to them behind your closed door. Again, we always advise people, these are law enforcement officers, so be courteous, be respectful, don't be combative, but know your rights. You have a right to remain silent. You don't have to answer their questions. You don't have to let them in unless they have a judicial warrant. Now, what happens if they stop you while you're driving your car to work? And this has been going on 1,000 times a day all over the country. Or you're driving to work, all of a sudden you see these blue lights flashing, blue, red, white lights flashing. They signal for you to pull over. Again, we always advise people, whenever you are stopped by any law enforcement official, stop your car, pull over, put your hands on your steering wheel. Do not move those hands to reach for anything until you are asked or directed to do so. Keep your hands in visible sight on that steering wheel. Roll your window down. Have a discussion with the ICE officer, if it's an ICE officer, or U.S. Customs and Border Protection officer, if it's the CBP officer. Have a discussion with the window rolled down. Do not move those hands until you are instructed to do so. Again, be courteous, be respectful, do not be confrontational, and please don't reach for items. They have weapons. They might interpret any unrequested move as a move toward aggression, as a move that might put their lives in danger. So keep those hands on the steering wheel until you are directed to move them. And again, invoke your Fifth Amendment right to be silent. You don't have to answer their questions. You don't have to tell them where you live. You don't have to, although you probably do not even have to give them licenses or registration, I recommend that you do. If they ask you for your license or registration, of course, give them your license or registration. But don't move those hands off that steering wheel until you are advised or directed to do so. Other than license or registration, the Constitution wraps itself around you. You do not have to answer those questions. Invoke your Fifth Amendment right to be silent. If they ask you to get out of the car, then please do so. Again, do not be combative. Be respectful, be polite, be as responsive as you can without depriving yourself of those basic fundamental and constitutional rights. Any questions about that so far? Okay.
For clarity, Mr. Walker, regarding the presentation of a signed warrant, is that something that we can request to be left with us, or we just have to recognize a signature on there?
Well, warrants that are signed by judges, you will see clearly that the signature and that the designation underneath is a federal state judge. So yes, you should certainly be able to see that it's a judge that has signed it and not a supervisory ICE officer from the Department of Homeland Security. Okay. Yes, ma'am?
This is kind of new to me, but because I go to a lot of Latin areas, I've been telling people that if you're not sure if it's a warrant, to hold it up to have them hold it up to the window and take a picture and, send that picture to an immigration attorney. And they can look at it and tell you if you have to open the door or not. Because it doesn't matter how long ICE is at the door pounding. You have it, as long as they can see you and you've taken a picture, they know what you're doing.
Yeah, that's probably a good recommendation. I have also advised people that if ICE comes to your home and you can't decide for sure whether that's a warrant signed by a judge, take a picture of it with your door shut.
Yes.
Let the officers know that that's what you're doing, that you can't be sure. Take a picture of it, present it to your immigration attorney if you have an opportunity to do that.
Where we get confused is that we've seen a lot of writs, not warrants. And I wish I could get one side by side, and I know that warrants are done differently according to which judge you go to. They don't have a standard, but we get confused as to writs and warrants. I know with a warrant you have to, but with a writ you don't. Am I correct?
Well, the federal standard for a search warrant or arrest of a person is pretty high. It's probable cause at least. It might be a little bit more than probable cause if you're seeking to get a warrant to arrest someone. But a writ and a warrant is not the same thing.
Okay, thank you.
Okay? Any other questions about that? All right. All right, so those are your basic fundamental due process rights if stopped, detained, arrested, or detained by ICE. ICE agents are federal special agents. They have more power because they're national security agents than the FBI. But they also have to obey the Constitution. And those people who are physically present in the United States do have constitutional due process rights. One of those rights is the right to remain silent. Another of those rights is a right to demand, if you are detained, a phone call to your lawyer or relatives so that you can let them know where you are. Again, another one of those rights is if they're going to search you. A lot of times when ICE is detaining people, they want to search their home and their person. Of course, a reasonable pat-down search of the person is probably legal, so that the officer can ascertain that there's not weapons on that person that might subject them to potential harm, but a more thorough search of that person, for example, your car, might require either a search warrant or probable cause by the officer. Yes, ma'am.
I know I keep asking questions, but I really want to get knowledgeable on this stuff. So, if you have a cell phone and it's activated by your face, and they hold up the phone to your face, they can go through it. But if you have to enter a code, don't they need a search warrant for that phone then?
Well, let's talk about two different scenarios. If you're coming into the United States at one of our port of entries, an airport, and this is what ICE is doing all over the country now. If, ICE, when you come to an airport, ICE agents or CBP agents have a computer there with a panel. Those panels have 9 buttons on them. Usually the CBP officers only need to press button 2 to find out who you are. It will give your biographic. It will tell the CBP officer what country you're a citizen of. It will tell the CBP officer whether there are any outstanding warrants and whether or not you're a member of a terrorist organization, button 2. If the officer, and this rarely happens, if the officer pushes button 4, they will know everything about you from the age of 12. Doesn't matter where you were on this planet. Button 4 will give them every piece of information about you from the age of 12. Now, directly to answer your question. So if you're coming into the United States at a port of entry, an airport, ICE CBP agents, since they're national security agencies, have the ability to examine and inspect you, your body, and your property without your consent. Because you are someone who's seeking admission into the United States, even a U.S. citizen coming back to a port of entry from a foreign trip abroad, gives CBP the power to examine you, your property, and your body.
You get pulled over by a police officer.
The laws are a little different.
Yeah, I was
Remember-
gonna say, can they go through your phone?
Well, remember what the Constitution does. The Constitution protects persons who are physically on our soil, who are in the United States. At the port of entry, you're not in the United States yet. You're knocking on the door to get in.
Right.
When you land on our soil, you are protected and wrapped around by at least basic constitutional due process rights. They probably can't search your phone or your person when you're physically in the United States unless they have, let me say, a high probable cause or a search warrant.
Okay, I was just wondering, because I do know that they do take the phones and they hold them up to people's faces so that they can access information to see if they can round up other people who also are in questionable status.
I do know that when ICE stops people inside the United States, they frequently ask for their phone. If you give them that phone, that's implied consent. You're giving them consent to examine it. Now remember what the Fourth Amendment says.
Right.
You do not have to succumb to a search of your person or your body or your property unless there's a warrant or a pretty high probable cause.
But with that warrant, can they then search the phone? Or
Sure.
do they need a different warrant to get the code from you to open your phone?
No. ICE and CBP's intelligence department can open any phone without any information from you at all. Okay. You gotta remember, people have to bear in mind that these are national security federal agencies. Their power is way up there compared to even an FBI agent. So, any other questions about that? Okay. So what can we do? What can we do as citizens, non-citizens, immigrants, non-immigrants, asylum seekers, Convention Against Torture seekers? What can we do here in the United States to protect ourselves, to protect our fundamental basic rights, and to also be respectful and obedient to our law enforcement officers and to the laws that govern their conduct? We start by knowing our rights that are detailed in the Constitution and in our state and local statutes and laws. You have to know at least what rights you have if you are ever detained, arrested, questioned, examined by a federal immigration, ICE, or CBP officer. Core rights: right to remain silent. I invoke my Fifth Amendment right to be silent. I want to talk to my lawyer. I'm not going to answer any of your questions. I don't mean to be rude, officer, but I know that is my right. I will not answer your questions. I want to call my lawyer. If you are detained, as many people are by ICE right now, and they offer you what's called an expedited removal order, we're going to just remove you back to your home country. We're going to notify your consulate, your embassy, that we have you in possession. We're going to seek their permission to send you back to your country. When they give us permission, we're going to seek you back to your country. No, officer, I respectfully decline that. I demand to have my case presented to an immigration court. Okay? Let an immigration judge, after adjudication and trial, determine whether or not I am removable from the United States, or whether I am one of the people who qualify from some relief from deportation and removal. For example, if you've been in the United States for at least 10 years, you have a U.S. citizen spouse, parent, or child who would suffer extreme and unusual hardship should you be removed back to your home country, the judge has the discretionary authority to let you stay in the United States and not deport you. If you are Yemeni, or if you are a citizen of a country like Nigeria, who is under war turmoil or directly involved in war, the United States cannot send you back to your country that's a war-torn country. They may send you to other countries if those other countries agree to accept you, but they may not. By international law, the United States cannot send Yemenis back to Yemen because it's a war-torn country. It's international law. Doesn't matter what the president says. Doesn't matter how many executive orders he issues. Cannot send them. You cannot send someone who's a citizen of Nigeria back to El Salvador. You can only send that person back to his country of nativity or back to some other country where that person has had some residence and status, as long as that other country agree. You cannot send them to El Salvador. It's a violation of everything we know about human, civil, international, and constitutional rights. They've done it. Of course, those acts have been deemed by several courts to be unconstitutional and illegal, and it's just going to be up to the appeals court and the U.S. Supreme Court to mandate that President Trump and the executive branch bring those people back. Now, there are other statutes that we should probably talk about. The Alien Registration Act. This was an act, a law, that was enacted by Congress believe it was enacted in the late 50s, 1954, and then again in 1972. It's an act that requires the following, and President Trump has issued an executive order to revive that statute. This is what the act says. All persons who are, and the act talks about aliens. I won't talk about aliens. I won't call human beings aliens. So let's just call them foreign nationals for right now. The act talks about foreign nationals who have entered the United States and who have remained in the United States more than 30 days beyond their initial authorization period. What the act says is that all of you, persons who are in the United States and you've stayed 30 days beyond your actual duration period, you must contact us and register with us. You have to tell us who you are, where you are, what your phone number is, give us other identifying documents. You have to go down to U.S. Immigration and have your biometrics taken. Alien Registration Act. Now, it is a lawful act because it was enacted by Congress, signed in law by the president at that time. It hasn't been used in 47 years. The last time we used it was when we put our Japanese brothers and sisters in prison, locked them up, and we had all other Japanese citizens in the country comply with the Alien Registration Act. So, do you have to contact U.S. Immigration? And the only way to do it is you have to have an account with USCIS. You go onto that account and you look for Form G325R. Form G325R. That's the form that's used to comply with the Alien Registration Act. And we have hundreds of calls a day from all over the country asking us, do we have to register? I'm a lawyer, so I can't tell you to violate the law. We'll always encourage you to comply with the law to the best of your ability, but you have to know the consequences of registering. If you do register, you are telling ICE and Customs and Border Protection and the FBI and U.S. Secret Service where you are. The only reason they want that information is so that they can come and get you. They will come and get you. They will detain you at an ICE facility. They will try and determine whether or not you have a lawful status in the United States. If you do not, they will try and send you back to your home country or some other country. But yes, if you are one of those people, you are a foreign national who have been in the country 30 days or more beyond your lawful duration of stay, you are supposed to register under the Aliens Registration Act. Okay? Any questions about that? Does that apply to U.S. citizens? Now let's talk about two different kinds of U.S. citizens. As many of you probably have heard, there is birthright citizenship, and there is derivative citizenship. Let me talk to you about birthright citizenship first. Our Constitution says this, and I want you to remember, our Constitution only in a few spots does that ever mention a U.S. citizens. When our Constitution talks about rights, the language it uses says persons. It doesn't say U.S. citizens. Persons who are physically on our soil are protected by these rights. Persons who are born in the United States are U.S. citizens. Okay. Persons. not U.S. citizens. So when you hear folks in the executive branch of the government talking about certain people don't have citizenship rights, that's false. That's misrepresentational. Anybody born in the United States, it does not matter whether or not your parents had a lawful immigration status. It doesn't matter whether your parents were married at the time you were born in the United States. Persons born in the United States derive citizenship, effective on the date of that birth. So someone from Albania, a woman from Albania who comes into the United States on a visitor's visa, she has a gestation period of 8 months. She's expecting a child, and the next month, that child is born in the United States. That child is a U.S. citizen. And that U.S. citizenship cannot be stripped by executive order. It can't even be stripped by federal litigation unless that federal litigation in a federal court demonstrates that that citizenship was obtained by intentional fraudulent means. The only way. Otherwise, nobody can rip that child, that person, of U.S. citizenship. Now, the other type of citizenship is one that's called naturalization. And there's a lot of times when, particularly green card holders, are people who have come into the United States. Can you hear me? Okay. Thank you. There's actually two other kinds of citizenship besides birth citizenship. When people talk about green card holders, what we're talking about are people who have come into the United States with a particular petition or application approval. For example, if you're a U.S. citizen and you marry someone from China and you file an immediate relative petition for that spouse that you just married, once U.S. immigration approves that petition, once the U.S. State Department does its role, once our U.S. consulate and embassy in China performs its function, that person comes into the United States with an immigrant status. It's an immediate relative immigrant status. But once that person comes into the United States, they have a green card or a lawful permanent residency status. Our laws say this: besides birthright citizenship, you can become a U.S. citizen if you've had that green card for 3 years, if it's based on marriage to a U.S. citizens, or 5 years if it's accorded to you through some other means. 3 years if you got it based on marriage to a U.S. citizen, or 5 years if you've got it through your employment or something. You can file for U.S. citizenship. What do you have to prove to get that U.S. citizenship? 4 things. You have to prove that you've had that green card for at least 3 years if it's based on marriage, 5 years if it's based on some other category. You are a person of good moral character and conduct. Now, what does that mean? Immigration law has a 5-year window. It looks back 5 years to see, have you been arrested? Have you been convicted of any crime? If you have been convicted of a crime that's a moral turpitudinous crime, It means it's a crime that shocks the conscience of your community. It's in violation of all the norms and values that your community hold. If it's a moral turpitude crime, you're not eligible for U.S. citizenship. Okay? So you have to prove you've had the requisite period of time for your green card, 3 or 5 years, that you're a person of good moral character and conduct. Number 3, that you can pass the citizenship examination. Citizenship examination consists of 3 parts. 1, you have to demonstrate that you can write English. Number 2, you can demonstrate that you can speak English. And number 3, which a lot of people have difficulty with, you have to pass the civic citizenship exam. Now, what is that exam? U.S. immigration has 100 questions that during the citizenship interview they can ask you, out of that 100, any 10. You have to get 6 right. 100 questions, they can ask you any 10 questions out of that 100, you have to get 6 right. What are they? Who's the President of the United States? Who's the Vice President of the United States? What was the significance of the Declaration of Independence? Who did we get our independence from? There are 3 divisions in our democracy. What are they? 3 branches in our democracy. What are they? There's judicial branch, executive branch, and there's the legislative branch, or Congress. Okay? So those are the kinds of typical questions that they ask you. If you get those 6 out of 10 questions right, you're a person of good moral character and conduct. You've demonstrated that you've had your green card for the requisite 3 or 5 year period. You become a U.S. citizen. That's a naturalization citizenship. So the first one is birthright citizenship. You're born in the United States. The second one is naturalization. You get citizenship. And the third one, which is called derivative citizenship. For example, let's say that your mother and father are Malaysian. So your mother and father were born in Malaysia, but one of your parents came into the United States quite some time ago and got U.S. citizenship, but moved back to Malaysia to marry his Malaysian fiance and spouse. So now they live in Malaysia. You were born in Malaysia, although one of your parents is a U.S. citizen. If you go to our U.S. embassy and consulate in your home country and you file a request, that request is called proof of a U.S. citizen born abroad. Our U.S. consulate can give you a document, an approval that certifies that you are a child born to parents in a foreign country where one of those parents was a U.S. citizen. You derive citizenship yourself from that. So the moment you step into the United States, whether you're 5 years old, 2 years old, or 50 years old, you are a U.S. citizen by derivation. Okay? So 3 types of citizenship. Now, the reason for talking about these citizenships is to let you know that those citizenships are a sacred part of our Constitution. And the only way anybody can take away those citizenships, not by an executive order, only if through federal court litigation, there is substantial evidence to show that that citizenship was obtained by fraudulent means. Okay? The only way anybody can ever be stripped of U.S. citizenship. Now, there are some other pretty serious ways. For example, if you participated in the persecution of someone in another country, you could probably be stripped of your U.S. citizenship, but that's going to take a long time and can only be done through federal court. Can't be done by executive order. The president has no legal authority or power to strip anybody of citizenship. The president, as a matter of fact, and I'm sure ICE will call me after they hear this, but that's all right. The president, nor anybody in this cabinet, can't even strip you of your green card. Your lawful permanent residency status can only be taken away by order of a federal immigration judge after adjudication in immigration court. So all this chatter you hear from the executive branch about how they're going to take this away and that away and we're going to arrest these people, they can't do it. Unfortunately, executive orders are part of the power of the presidency, and until a court enjoins that action, the executive orders have to be obeyed by the administration and the staffers and the employees of the executive office. So it takes a long time for these matters to get through court. Ultimately, they will wind up at the U.S. Supreme Court. And as we probably saw during the last week, already 90% of those executive orders that has to do with immigration and detention of people have been enjoined by the courts. So, okay. Citizenship, 3 types. You're born in the United States. Doesn't matter whether your parents are lawful status holders or not. You derive it, or you obtain citizenship by naturalization. You go through the N-400 process where you submit an application. You demonstrate that you've been a green card holder for 3 or 5 years. You demonstrate that you're a person of good moral character and conduct. You've passed the civic exam. You've passed the English reading and writing exam. You're a citizen. And the third one is derivative citizenship, where you derive citizenship because one of your parents who live abroad, and that's where you were born, in Malaysia, the moment you step foot on U.S. soil, if our U.S. Embassy and Consulate has certified that U.S. citizen child born abroad, you become a U.S. citizen the moment you land on U.S. soil. It doesn't matter how long it takes you to land on U.S. soil. If you're 100 years old and you land on U.S. soil, you're a U.S. citizen. Okay? Any questions about it? Yes, ma'am.
I'm just wondering, can executive order stop a Puerto Rican from being a U.S. citizen? Because Puerto Rico is considered a commonwealth. And can the president sign an executive order? Because since it's not really considered part of the United States, it is and it isn't, because it's a commonwealth. And if they're born in Puerto Rico, can he stop them from being citizens?
Puerto Rican citizens are U.S. citizens,
Even though it's a commonwealth.
even though it's a commonwealth.
And an executive order won't stop that.
No, and the only thing that,
Because so is Guam.
so is Guam. The only thing that Puerto Rico can't do is they don't have electors that can participate in federal voting. But their citizens are U.S. citizens. So as long as you are born in Puerto Rico, you are a U.S. citizen. No, executive orders can't stop that.
Okay. Could it change the status of Puerto Rico from a commonwealth to a state?
Well, again, you gotta remember the reach of the presidency. Now, I know people hear all this talk from President Trump about what he wants to buy Greenland. He wants to do. The president has limited constitutional powers. He cannot do that.
Okay.
No, he cannot do that. Now, the reason all these executive orders continue is because most of the power that the president is trying to exercise is powers that belong to Congress, the Republican Congress. But Congress isn't stepping in to stop him right now. So he gets a little bit more latitude to exercise the powers that he doesn't really have, but he doesn't have the power to do that, no. Not the legal power to do it. Okay. All right, any other questions? Let me get back up here to my notes, if you don't mind. All right, so I don't know what else I can tell you. Okay.
Can a person ask for asylum if they are already in jail? Or
Well, that's a great question. Well, let me tell you what our political asylum law says. Again, remember, political asylum is an application to the United States government that says, I'm a citizen of Iraq. I fled Iraq because I was harmed by my government. And it's got to be the government. It can't be gangs, it can't be people, it can't be your next door neighbor that you've had a fight with. It's got to be conduct by the government. I fled Iraq because the Iraqi government harmed me because of my race, my religion, or they harmed me because I'm a Sunni instead of a Houthi. So, our asylum law says this: if you come into the United States, you have to apply for asylum within 1 year of coming into the United States. Now, there are some exceptions to that. If you could not file within that year because of exceptional circumstances beyond your control, and you can prove to U.S. Immigration Court or to the U.S. Asylum Office that these exceptional circumstances prevented you from applying within 1 year, then you can still submit an application for political asylum. But our statute and our convention with the United Nations Treaty on Asylum says that you have to apply for asylum within 1 year of coming into the United States. Young lady, did I answer that question? Now, can someone who's physically, for example, we have thousands of people who are in detention right now from foreign countries who have applied for political asylum. So you can always, if you're placed in deportation and removal proceedings in immigration court, you can always tell the judge that that's one of the reliefs from deportation that you will be applying for. But if you can't prove that exceptional circumstance beyond the 1 year filing deadline, the judge isn't going to actually accept your asylum application. But it doesn't matter if you're applying for asylum as you come in at the port of entry, or whether you apply for it while you're physically located in the United States, as long as you could apply within 1 year or show that exceptional circumstance. Yes, ma'am?
Entry or 1 year after you go through that decontamination?
1 year from your physical presence in the United States. Now, again, there is an exception for circumstances beyond your control that prevented you from doing that. For example, if you were in the hospital with surgery for 7 months, you couldn't submit an asylum application. That's an exceptional circumstance that's acceptable. Okay. Young lady, did I answer your question?
there's another question.
Okay.
Can a person request adjustment of status, migratory status, if that person is a foreign national married to a DACA beneficiary?
Well, even DACA recipients
Right.
can't apply for adjustment of status because that's not a lawful immigration status. It's a deferred status. It simply defers the person removal and deportation. So even a DACA recipient can't apply for adjustment of status. So the spouse certainly would not be able to apply for it. By the way, DACA has been stripped. President Trump has issued an executive order stripping people of their DACA status. So DACA recipients can no longer apply to either extend or to get new DACA because President Trump issued an executive order. Yes, ma'am. DACA means Deferred Action for Childhood Arrivals. That is, there is what? 690,000 people who came into the United States as children. They were 6 years old. They were 9 years old. They were 15 years old. They were brought here by a parent or a guardian and left here. So Congress, this was actually under President Biden, President Obama. Congress enacted a regulation that says that those children who were brought here, left, and abandoned by their parents could apply for deferred action for removal. So that's what DACA means, Deferred Action for Childhood Arrivals. It gives them a status. It allows them to temporarily stay here, to go to school, to live with guardians or other domestic people in the United States who would care for them. It was enacted in 1992. In order to get it approved at that time, you had to show that you were brought here by a parent or guardian, that you were left here, that at the time you were under the age of 16, and that you've remained here ever since. DACA. It's not a status. For example, you can't go from DACA to a green card or DACA to U.S. citizenship because it's not a status. It's a deferred action. It means we are putting off the time when we send you back to your home country. Yes, ma'am.
And while they're here, they have children. And then that asylum is taken, the right to seek asylum is taken from them. Do they take their children with them, or do the children stay behind?
Are you talking about children who were born here?
Right, and the
Okay, yeah.
parents are being deported.
Now remember, anybody born on U.S. soil is a U.S. citizen. Now that child who's a U.S. citizen has a right to remain in the United States. Nobody can force that child to leave. Now the parent, of course, is the presumed legal custodian and guardian of the child. Even though the parent might not have a lawful immigration status, they are still the presumed legal guardian and custodian of that child. So that parent should be able to make decisions about what happens to that child. But nobody can force that child to leave the United States.
And sign a guardianship paper and give guardianship to a friend, a neighbor, a church member, so that the child can still stay here?
There is a status, and I'll talk about guardianship in a little bit. There
I'm
is
sorry,
a
I
status
shouldn't.
that's called SIJS, Special Immigrant Juvenile Status. And this is a status that is conveyed to children who don't have a legal parent or guardian here. Special Immigrant Juvenile Status. It's a 3-tiered process. You first have to get an order from a probate judge that says that this child is without legal guardian, parent. Therefore, we, the court, become the child's guardian. And after the probate judge issues that order, you take that order to U.S. Immigration Agency, and you file for a special immigrant juvenile status for that child. That's a green card for that child.
That doesn't mean that they give up parental rights. It just means that they're giving their child
Well-
permission to their child to someone else, guardianship?
Now, that's a probate question, and I'm not a probate lawyer, but let me tell you what I think. I don't think the probate judge will issue a guardianship order for somebody else to become that child's guardian unless that parent is either out of the United States or has no ability to care for that child.
But that parent does not have to give up its rights. Just, because there's two different things here, right? There's the termination of parental rights, and then there's the guardianship, transferred guardianship.
You know, could the probate judge demand that the parent exercise a termination of their rights? Probably, but I don't think the judge would do that.
Okay.
I think I think the judge would deny the guardianship since the legal parent is right here. They're physically present.
Right.
Even though they don't have a lawful immigration status, they're still physically present in the United States and can presumably care for the child. So why would the judge give a guardianship? So, now that's just my guess again.
It's just that, okay, I
But-
don't like to give out too much information, but I do know people that are being deported to Venezuela, and they're giving up their guardianship to their children in hopes that the children will stay out of, even though they're born here in the United States, so that the children, they don't take them with them to stay to all the detention centers and to go through all of that to get to their country. Once the people get to Venezuela, they cross into Colombia and they're met with their children, because the United States can travel to Colombia, but not to Venezuela.
I can see a probate judge saying, okay, parent, if you have to leave the country by force or you volunteer to do so, and your child stays here, yes, of course, I'm going to appoint a legal guardian for that child.
Okay.
And then that legal guardianship order gets filed with a special immigrant juvenile status application. It's called a I-894 with U.S. Immigration, and U.S. Immigration gives that child a green card.
Okay, thank you.
Well, she's asking that she got detained in the border with Canada. She took the wrong turn in the state, so she got detained there. So she's got an appointment or a hearing for June 3rd next year, 2026. So at this point, also
A hearing where?
I'm sorry,
Where is the hearing?
in Detroit.
No, I mean, is it with ICE? Is it with
Oh.
U.S. Immigration Court? Is it with?
It was ICE.
Well,
And also, her daughter is a U.S. citizen, and she applied for, she's, I don't know what the form, what form they applied for, but they filled a form a month ago. So she's, to try to get her mom's immigration status, what is it?
is the daughter 21 years of age or older?
Yes.
Because a daughter can only, a U.S. citizen daughter or son can only apply for a parent if they're 21 years of age or older. And the reason for that is because under immigration law, a child is someone who's under the age of 21. So if you're 20, under U.S. immigration law, you're a child. Under state of Michigan law, you're an adult. So you can only apply for a parent if you are an adult. So that child would have to be 21 years of age or older to apply for her mother.
Yeah, she is 21
Okay.
years old.
Now, when someone's detained at a port of entry, what usually happens is the following, one of three things. They're either denied admission, sent back to wherever they came from, or they're given an expedited removal order. That expedited removal order says this: you are deemed to be inadmissible to the United States, you do not have the requisite visa, or you do not have the requisite documents to show that you are legally able to come into the United States, we're going to remove you. And that removal is a 5-year removal. You can't come back into the United States for at least 5 years. Now, sometimes at a port of entry, when Customs and Border Protection issues an expedited removal order, they ask you, do you want this to go to immigration court? Do you want a judge to decide this instead of me? If you say, yes, I want to go to immigration court, they detain you in one of ICE detention facilities until your immigration court matter is over. Now, sometimes, if you're not a threat to the community, you don't have any criminal convictions, you have given ICE information to locate you inside the United States, they will parole you into the United States. Even though you're still under detention, they will let you come into the United States and stay until your immigration court case is over. Now, I say that to you. I have, just in the last week, I must have 70 people across the country who has been detained by ICE. I have to go to Arizona 2 days from now to try and get some of these people out. I have a client who was driving on Highway 87 in Arizona with a truckload full of asparagus. He has a green card. He was pulled over and stopped by Customs and Border Protection because he's within 200 miles of the border in Arizona. And our law says, care who you are. We don't care if you're a U.S. citizen or if you're the President of the United States. If you are within 200 miles of any border, ICE or CBP can stop you, examine you, detain you, or arrest you if necessary. So they arrested my client, who's driving his commercial truck. He has a green card, $320,000 worth of asparagus, and he's sitting in jail now in San Diego, so I gotta go there and try and get him out. But, you know, that's what happens when either you come to a port of entry, you are either denied admission, or you're given an expedited removal order. If you don't want to go to immigration court, they will expedite your removal back to your home country. You can't get back into the United States for a minimum of 5 years. If you go to immigration court, if you choose that, the officer can parole you into the United States and let you stay here until your immigration court matter is over. Now, for the young lady, the person that you talked about who came to, is it the port of entry from between Canada and Detroit? Was it the tunnel or the bridge? Huh? Okay. Is she in detention now?
They gave her a court date. They
Okay.
released her.
So they paroled her into the United States. She has a court date in immigration court.
Yes.
Okay, not ICE, immigration court.
Yeah, immigration.
Okay. Well, you tell her, immigration law, federal government says immigration law is the most difficult and complex specialty in the law. Nothing comes close to it. With every immigration case, you have to comply with 80 immigration regulations and maybe 34 statutes. It's the most difficult there is in the law. Nothing comes close to it. Tell her to go get an immigration lawyer. Doesn't matter who it is. Get an immigration lawyer, let them help you. Okay. Okay. I don't know what else. I have given you guys, I'm an adjunct immigration law professor at the University of Michigan Law School. I have just given you guys Immigration Law 101. So I don't know what else I could add to that. So I'd be happy to answer any questions that you might have. Yes, ma'am. You mean the equal protection aspect of the 14th Amendment? There's so many different parts to the 14th Amendment. Okay, well, yeah, let me address that one more time so that you understand it. People born in the United States are U.S. citizens. There's no color in that. There's nothing black and white in that. That is firm. That can't be taken away by executive order. Can only be taken away through litigation, federal court, with a trial, where there is an overwhelming amount of evidence to show that that person obtained U.S. citizenship by fraudulent means. Only way. Now, there is one other way that I talk about, and this is historic. There have been times in our history where citizenship have been taken away from someone who they had sufficient evidence to show were Nazi in Germany. They were Nazis that helped persecute, torture, kill our Jewish brothers and sisters. Okay, so. Okay, now you're gonna have to repeat that.
What will happen to the baby's citizenship if they can prove that the mother took her visa while she was pregnant and she did not tell the officer that?
She was pregnant?
Yes.
I'm not sure she has to disclose to the officer that she was pregnant. A lot of people come into the United States on visitor's visa when they are in their gestation period. Well, the most direct result would be to deny or take away her right to enter the United States, the mother's. But again, that you can't take away a birthright citizenship because the parent did something wrong. Okay? And that's what Trump is trying to do. You can't do that. It's illegal, it's unconstitutional. So the action would be against the mom, not the child. Okay? Okay, guys. I think I'm done, unless there are other questions, okay?